Hello, everyone, and welcome to Uncivil Law. For today's stream, what we're doing is we're going to react to an ongoing stream relating to the Jennifer Crumbley case. That's super exciting. And just for a reminder, by the way, the Crumbley parents were convicted of manslaughter in relation to their child doing a school pew-pew. The child, of course, himself was convicted, as is, of course, proper and right and good. But very concerningly, the parents were also convicted of manslaughter, which raised a lot of very interesting and complicated legal questions as to being able to hold the parents responsible for the conduct of their child. And it doesn't really work, at least legally, it shouldn't work because this is an intentional act. So the intentional act by a person charged as an adult, nonetheless, should break the chain of causation. So like normal law 101, right? I'm sort of responsible for what I do and you're responsible for what you do, right? So if I do a thing and bad things occur, I'm responsible for that. But if someone else comes in and makes a deliberate decision to do bad things, that breaks the chain of causation because now you're responsible for the bad thing you do. It makes perfect logical sense. So just by way of like example, so we can make this a little bit less abstract. If we're talking about a murder, right? So let's suppose I want to charge Jones with killing Bob. Okay, Jones has shot Bob. Okay, all right. So Bob dies right away. Jones is guilty. That's no problem. All right. So what if Jones lingers on for a while, and he dies in the ambulance? And I later determined that it was because of the ambulance negligence. No, Jones is still guilty, right? It's like, okay, what if he makes it to the hospital, right? And the doctor screws up. No, Jones is still guilty. All right, let's suppose that Bob is conscious when he makes it to the hospital. And the doctor says we can do option A or option B. Option A is really, really dangerous. And Bob says, I really like option A. And the doctor says, are you sure? Option B is a lot safer. But Bob says, I really like option A. I don't really think option A is the way to go here, Bob. I'd really go with option B. No, I really am fond of option A. And the doctor says, okay. And then the doctor does option A and Bob dies. Well, that sucks for you, right? Because, I mean, you're the one who put him there. You're the one who put him there. And so you sort of take the risk, right? And it's like, yeah, even if ill-advised, even if all the other things. But if the doctor makes a deliberate decision to actively kill you, like he stabs you in the heart, then obviously that's a little bit different, right? Because now he's making the intentional act that breaks the chain of causation. Okay, so the intentional act is the thing that breaks the chain of causation. And here you have a person charged as an adult, even though they're a kid, but they're charged as an adult who you say made a deliberate decision, an active choice to go into the school and pew-pew everybody, right? So that should break the chain of causation, but it doesn't break the chain of causation for some reason, which doesn't really make sense legally, but that's where we're at. Right? It's a very weird thing. It's a very weird thing. Like holding parents responsible for their kids' acts when they're relating to negligence. Yeah, you have a duty to supervise your children. So if your child is in a store and you're not watching them and they break some stuff, you got to pay for it, right? Because you have a duty to supervise your kids. So that like concept isn't that weird, but there's a difference between, you know, yeah, it's a very, very weird legal concept. I don't quite buy it. So how old was the kid? 15, 16? I'm not sure it really matters legally because we're charging them as an adult. I'm not sure it really matters how old the kid is. I'm not really sure it matters in this equation how old they are. We're charging them as an adult. So they're an adult enough for the purposes of their own trial. So I'm not really sure it matters, but I think they were 15, but I'm not sure it matters. But anyways, we've got this hearing. And so we're going to watch this hearing and learn a little bit more about what is going on relating to this. Also, immunity agreements weren't disclosed to defense, but the prosecution doesn't care. Yeah, that too. There are a lot of other things that's going on. Oh, and also, of course, as is mentioned, also, you hand your kids off to the school. And there is this idea of in loco parentis. So the another thing that breaks the chain of causation is that the school, in some senses, takes the place of the parent. That's the whole idea of in loco parentis. So it's not even clear that within the context of this, they're under the supervision of the parents at all, because the school becomes the parents to some limited degree. This is a concept that goes well deep in law. There's a lot of weird things about this case in terms of its legal posture. So I don't, can't hold the school accountable. I'm not so sure that they can't, as they didn't, right? They didn't charge the school. That's not the same thing as they can't charge the school. So yeah. So let's watch this hearing and see a little bit what's going on. Let's get started with this.
Trials. I believe and understand you, Your Honor. But the point I'm making is it's not cumulative. So, for instance, in the Chenot case, the People versus Chenot, the 2014 Michigan Supreme Court case.
That's the MACD. Right?
I thought the courts ruled people couldn't sue the school. First of all, those are different questions. Sometimes you can sue the school, but whether or not you can sue the school and you can charge the school are two different things. Civil law is not the same thing as criminal law. So can you sue the school and can you charge the school? Definitely not the same legal question. But fair point.
Michigan 142.
That's correct.
So, assuming for the sake of argument, I haven't heard from the prosecutor yet today, assuming for the sake of argument that I agree with you that the prosecutor violated the rules of discovery, right?
Yeah.
I need to know what you say the remedy is.
Well,
I agree that credibility is always at issue. If I had $1 for every time I said that, I could retire right now. Credibility is always at issue, and it's clear that the statements of Mr. Ejek and Mr. Hopkins would potentially be used in charging decisions with regard to them. That's clear. But if you go further and reach to know, the difficulty is for the court to find there's a Brady violation, I would need to find not only that the prosecution suppressed the evidence and that it was favorable to the accused, but viewed in its totality, it's material, right?
Yep.
And it's material, it's exculpatory or impeaching.
that's correct. So, that's correct. I agree with that. But in the Chenot case, let's just be clear about why the Chenot case is not a good template to decide this issue. In Chenot, the Michigan Supreme Court said that there was a suppression, there was a violation, but that it wasn't material. Why was it not material in Chenot? Because that witness did not have any sort of cooperation or immunity agreement. And so that witness, there was no basis to attack that witness for bias or motive for what she was saying. I see you want to ask me a question.
Well, if you knew how many times I read this, it would. Okay, so.
And it was also cumulative in Chenot, and it's not cumulative here because they couldn't get those subjective descriptions from anywhere else except these two school officials.
Okay, but what part? What would be missing? That she came to the school and she left without Hopkins,
Yeah.
Mr. Hopkins and Mr. Ejek. You still have she came to the school, she left
Yeah.
the school. She wasn't with her son. Obviously, no one searched the backpack. Everyone was very disturbed by that picture.
Yeah.
And minutes later, right?
Yeah. So here's why it's material.
And minutes later, when the shooting starts,
Well, it's hours.
2 hours.
Yeah.
She doesn't think to herself, "Oh, I'm so worried about the safety of my son." That's not what she thinks.
Well, we don't know. That's what.
She says, "Ethan, don't do it."
Well, that's after the fact. But I want to back up to the meeting because you asked me why is that testimony so important and material. It's not just the time people arrived and that they left. Here's what they said. Okay, this is Mr. Ejak testifying that he had an expectation that they would be leaving from the meeting with their son. He said, "It seems a little odd based on my experiences." So they were trying to lay a predicate that would satisfy the gross negligence standard that didn't come from anywhere else in the trial, because that meeting is where the prosecutors say Mrs. Crumbley should have done something or taken her son.
Okay, but how is the testimony? There's a difference between the credibility of the witness. I agree with you that the credibility of the witness is always at issue. And, so there would have been robust cross-examination by Ms. Smith, right?
Mm-hmm.
But the problem is the defense could attack the credibility of Mr. Hopkins or Mr. Ejek based on the proffer and the fact that they knew the proffers would be used in a charging decision, right? But the prosecutor says the problem with that is that the testimony of Mr. Hopkins and Mr. Ejek about the 12 minutes your client was at the school is consistent with what your client said happened in the meeting, and still would have been even after robust cross-examination. In other words, that the jury didn't have to believe Mr. Hopkins or Mr. Ejek over your client to convict her. They could believe all three as well as the rest of the evidence and still convict.
I disagree with that, Your Honor, because the prosecution is essentially trying to put us in the box that says the only way we could have impeached those witnesses was with a prior inconsistent statement from the proffer. That's not my argument. That's not my position.
No, I get it. No, it's not a prior inconsistent statement.
I don't.
It's you went and talked to the prosecutor's office and you knew whatever you said could be potentially used in a charging decision, right?
Yes.
Yeah, I get it.
Oh, right.
Yeah.
But it affected their credibility as to these subjective descriptions about, well, it was odd to me. She was in a hurry. She just wanted to leave. She said she had to go to work. Those are all
She
subjective.
testified, she said, are we done here?
No, she testified, Your Honor. I'm sorry to respectfully, just to correct the court. Mrs. Crumbley testified
Don't give me
that.
the transcript, by the way.
Yeah.
I got this doorstop, but this is the guidepost report.
Yeah, I know. I'm sorry. I gave you so much papers. Mrs. Crumbley testified, page 223 of her testimony. She was asked, did you mean to be abrupt about ending the meeting? I didn't think I was abrupt. Did you think you ended the meeting? I think it just automatically ended. So this is the dispute between those witnesses and Mrs. Crumbley. She couldn't refute.
That's not your brief. Your brief doesn't say
It's right here.
that if we knew about the proffer, the testimony would have been vastly different.
Well, actually, to be honest, Your Honor, I think without the proffers, if they wouldn't have secured the proffers, if those witnesses would have asserted the Fifth Amendment and they hadn't testified at all, Mrs. Crumbley wouldn't even have needed to testify because she wouldn't even have needed to try to rebut these subjective descriptions from the
She
witnesses.
wasn't called to rebut them.
Well, I disagree, Your Honor.
I think she was called to humanize her.
Well, perhaps, but there's a twin purpose of it because Ms. Smith, trial counsel, certainly asked, well, did you mean to be abrupt? She says, I don't think I was abrupt. Why is that important?
Okay, but you're arguing that she couldn't have been convicted without Ejek and Hopkins.
Yeah, I believe she could not have been convicted without Ejek and Hopkins. That meeting was key. Let's not forget, the prosecution's theory is that Mrs. Crumbley should have and could have done something at that meeting, and so they portrayed that meeting in a certain light, which was she was uninterested, she was in a hurry, she had to get back to work, she didn't seem to, it was very odd to me. We had other meetings before, but this one was odd, this one was different. Those are subjective descriptions that they can't run from that, and how could the defense contest that? I don't believe Ms. Crumbley could have been convicted without the testimony of Ejek and Hopkins, because that meeting was the linchpin of the gross negligence insofar as the prosecution's theory was she should have done something then.
Okay, wasn't the linchpin of the conviction the fact that there was that picture, it was sent to her, there's things all over Facebook about the gun that he got for Christmas.
I don't disagree that some of those things.
Don't get caught looking for bullets on your phone.
Your Honor, I believe that those things in part could contribute, but we cannot now parse out after the fact the import of those two individuals' testimony juxtaposed against the other things that Your Honor is pointing out. So why would they have called those witnesses? What was the reason? Let's just think about it for a second. What was the reason for calling these witnesses to begin with? Because they could not establish the basis of what happened in that meeting in order to then say to the jury, she could have taken them at the meeting, she could have went and got counseling, and we already know, Your Honor knows, they did not require the parents to take their son. They said, no, he can stay in school.
Okay, but how does that matter? Any parent could come and pick up your child at any time, right?
How does that matter? Well, because
No, you're
because ultimately the jury was being asked to decide, do you think...
taking them home regardless.
Sure, she could have, but they told her she didn't have to, and that there was the plan that he should be around his peers. So they made it optional, but this is where they tried to sway their testimony to help the prosecution, where they say, well, but we thought they would take them. Okay, so you either thought you would take them or you were going to require them to take them. Which one is it? And it's my argument, Your Honor, that the prosecution was unhappy with what some of the statements of those witnesses. So they got up on redirect to try to bolster them by saying, well, but what did you think was going to happen? Well, I thought they were going to take it. It was my expectation. That's substantively different. So the reason they called him was because they wanted the jury to hear this moment in time, 2 hours before the shooting. They wanted to focus on what the Crumbleys could have done, and what they ended up saying was, well, we thought they should take them, and it was odd, and you know, she ended it abruptly. She didn't hug her son. Did they hug her son? No, she didn't hug her son. Those are subjective descriptions that wouldn't have come in from anywhere else. The jury was left thinking, well, these two school officials are noble and selfless, and they're just here to tell us what happened, without knowing that they were under the threat of prosecution. Let's not forget, the prosecution...
They were still under the threat of prosecution.
Sure.
You know, part of the problem is, in your brief, is you assume that, or think that if Mr. Ejak and Mr. Hopkins were charged, then that exculpates your client. All four of them could have been charged. Yeah. In theory.
Sure.
In theory.
Sure. And a jury also could have said, well, if these guys are facing criminal prosecution, then we should be thinking more about what their failures were. And maybe it wasn't that she was grossly negligent. They didn't know that. So back to my point, the school officials could come in and look noble and say, oh, we're just doing this. And Your Honor, just to remind the court, the prosecutor announced the date after James's verdict that they wouldn't charge the school officials. So why is that important? Because they dangled that carrot over those witnesses to get them to cooperate and to come in.
They were probably never going to charge them.
I agree. I agree they were never. I agree they were never going to charge them, but they had to keep that in place until after the trial. They had to keep that threat of prosecution in place until after the second trial, and they obtained their guilty verdict. You don't like that?
I don't know.
Well,
I think they had their hands full with the two trials that we did.
If this isn't materiality, I don't know what could be materiality. And the Chanel case, the suppressed video statement.
I tend to agree with him on the law. The question of materiality, it's like these are essential witnesses, right? So if the testimony could come from somewhere else, then it wouldn't be that big a deal, right? And so you see that in other cases. So if you had, I don't know, 3 different eyewitnesses and one of them is for some reason problematic, you still have 2 other eyewitnesses. So if the jury hears from all 3, and for some reason you find out after the fact that one of them is no good, you still have 2 more to go. So they're not strictly speaking essential, right? They were nice to have, but they weren't essential. These are kind of essential witnesses because no one else can testify to what happened in that meeting except for them. And what happened in that meeting is very material to the state's case, at least the way they presented it. They presented this as a theory of negligence, and the theory that like the negligence, that they had this sort of last chance to take the kids out of the school, and they didn't do it. And so, okay. And so this proffer with this immunity can be used to challenge their credibility and say, okay, this is a reason that you might be lying or something, and the defense didn't have that. So it goes to the heart. So it's evidence that potentially can be used to impeach the witness relating to prior testimony or entire agreements. So Brady and Giglio, and then the materiality because they're essential witnesses. Because without them, that element of the state's case falls apart. And they're because it is the thing that happened last in time. Yeah, I mean, I think he's right. I think he's right. I think it's material under the law. So I think he's right.
Statements, as the Supreme Court said, a couple things that are markedly distinguishable from this case, Your Honor. One, they said it was cumulative This isn't cumulative, as I've already described to the court. What they said about their subjective descriptions was not cumulative of anything else. That's number one. So it wasn't cumulative. Number two, in the Chenot case, they said, well, there were only minor inconsistencies, nothing substantial between the statements of the witness and the recorded statements that were not produced. So fine, they
Trump
had
is doing a
marginal
press
value.
conference?
You're going to say, well, their proffer statements weren't really inconsistent. I agree with that.
Should we-
The proffer statements weren't inconsistent, but that
Should we do this again? We got to do this again, right? We're compelled to do this, right? So we gotta switch over to the Trump press conference, and then we got to switch over, right? Okay, yeah, that's what we're doing now. All right, let's do this thing. Give me a second. Hold on. I can't find Trump doing a press conference right now. I can't. I don't see Trump doing a press conference right now. Right side? Okay, here we go.
It's like in
Wait a second. This is yesterday. Yep. You can't read, can you? You can't read, can you?
her passion for
Okay, so this is right side broadcasting. This is right side broadcasting. What does it say in the top right corner? What does it say in the top right corner of right side broadcasting stream? Yeah.
That only assumes the only way to impeach the witness is by a prior inconsistent statement. That's simply not true. You can also impeach the witness by motive and bias, and that's what the purpose
No,
was.
see, do you know the difference between right and left? Do you know the difference between the top right corner and the top left corner? Do you know your right from your left, sir? It says live in the top left corner. What does it say in the top right corner?
So let's not accept the idea that if the proper statements themselves were not inconsistent with the trial testimony, there's nothing to be done here. That's false. That is an incorrect assumption because it has nothing to say about the actual motive and bias of those witnesses.
And to be fair to the chatter, this is incredibly poorly phrased because you're absolutely right. Look at what they titled it. Live. White House press secretary holds press briefing and Trump signs executive orders 131-25. Right side broadcasting is lying to you. Their title is lying to you. Right side broadcasting sucks balls.
Was absent in the Chenot case because that witness didn't have any proffer agreement or cooperation agreement.
All right, what else?
What else? They wouldn't have testified without the proffers. So back to the point.
Okay, but
And then they wouldn't have had that description, the damaging testimony. She was in a hurry. She didn't care. She wanted to get to work.
they have a video.
But not of what was said. We don't have a video of those. Those were subjective descriptions. It couldn't have come from anywhere else except the two witnesses.
What specifically? That's a very small part.
What's my go-to for press conferences? At the
Well, I
moment,
don't
the
think it's-
White House's
Well,
YouTube
but that's the
page.
key evidence. It's the last interaction between the parent.
If you want, is like, what is your go-to source? What is your go-to source for press conferences? How about the White House YouTube page? That's a pretty good one. That's a pretty good one. The White House YouTube page is probably a pretty good place to start. Yeah, that sounds good.
And the school officials and the son.
Why is that the key evidence?
Because when they
She
argued,
goes to the school and she leaves the school. Her and Mr. Crumbley.
because they said it seemed a little
Lord.
odd based on my experience. That's page 45 of EJAC's testimony. Typically, he says,
I have been
typically, he's trying to
bamboozled
help
by the
prosecution.
chat.
Typically, parents
I have
follow
been
the direction.
boozled and misled.
He says, I did think it was strange they didn't take their son out. That's page 71. The expectation, well, my expectation was that he would be leaving with his parents. Those are all subjective descriptions.
Wouldn't the meeting
that
be
only could have
hearsay?
come from-
Not if the witnesses are in court to testify as to what they said. No, then it's not hearsay because no, it's no longer out of court. Now it's in court, right? So if the witnesses are in the courtroom to say, hey, at the meeting, I said this, right? They're not relaying what someone else said. They're relaying what they said. They're not relaying what they heard. They're relaying what they said. And they're in court to say it. So no, that's not hearsay. If they said what someone else said, it would be hearsay. Although in this situation, the other person in the room is the defendant, of course, that's a hearsay exception. So no, it's not hearsay in this situation.
Those witnesses, that your honors, your point is, well, we know what time they got there. We know what time we left. Sure, we know there was
We
a
know what
meeting.
happened before that, and we know what happened after that.
But the prosecution's theory was, in closing, they were at the meeting and they could have taken these steps at that time, but they weren't interested. They were in a hurry. She wanted to go back to work.
Okay, but
So-
they don't need EJAC and Hopkins for that.
I think they do, because well, how could they make that argument and say she was in a hurry, she wanted to go back to work without their testimony?
Well, she obviously did not tell them that they gave him a gun for Christmas, and that it was all over Facebook, and that she had heard about the bullets the day before, and that there was that horrendous picture, right? That picture that should be disturbing to any parent that was sent to her. She was so disturbed by it, she showed it to someone she worked with, right? And then she goes there, and did EJAC and Hopkins check the backpack?
No.
But she didn't check the backpack either, right? She didn't check the backpack either.
Well, as we know from at least the Guidepost report, the Guidepost investigation found that they should have checked the backpack,
Don't be
and
hurt when I tell you we didn't read it.
I won't be hurt because
It's not relevant to
it is 563
It's
pages.
not relevant to these proceedings. And sadly, I know most of what's in there firsthand.
It may not be relevant per se, other than to show the context that these individuals were facing. If the parents were grossly negligent, then the school officials could have been grossly negligent,
Probably.
and the jury could have decided where they wanted to place that amount of blame, whether to reach guilty on the gross
No,
negligence.
that's like a comparative negligence civil theory or something.
No, Your Honor, it's
Like, okay, do you think that you were going to tell the jury, okay, these three all messed up, pick one?
the standard is beyond reasonable doubt, Your Honor. I don't need to tell you that. I know you know. That's all they needed to do was create some doubt, and they shored up any doubt that may have existed by virtue of bringing in those two schools. I feel like what I'm hearing from the court is that this meeting was inconsequential, and I'm reading this.
It wasn't inconsequential, but you're telling me that if there wasn't testimony about what happened at the meeting, or if their credibility was in doubt, which it would have been, their credibility would have been in doubt based on these properties. You're telling me that if all that happened in the meeting was not presented to the jury, your client wouldn't have been convicted. That's what you're telling me, and I think that's a big leap.
Well, hold on, Your Honor. Let's back up. The Chenot case in the Michigan Supreme Court, they made clear, I don't have to prove to you that we would have won an acquittal. I only have to prove there's a reasonable probability that the outcome could have been different. And then Justice McCormick goes on to write what that means. And it means that there's a lack of confidence now, because looking back, we have to say, and Your Honor's pointing out this. Fine, that's fine. We have all these things. But how can you take out that damning testimony from those two individuals, their subjective damning testimony about what they say, oh, she's in a hurry, she doesn't, this was odd, this was unlike other meetings. That's damaging testimony. So you might right say, well, you had 8 other pieces of evidence, and you're telling me, Mr. Desi, you want to remove the 2 pieces, but isn't 8 enough? No, it's not a sufficiency of the evidence standard.
Whether it undermines the confidence in the outcome.
It absolutely undermines the confidence of the outcome, because they could not have received that testimony of that nature from anybody other than those school officials. But this is, and I know I've said it a few times, and you're probably going to tell me to stop saying it, these were subjective, these were highly subjective descriptions of what they believed was Mrs. Crumbley's mindset. And that is what the jury heard, with it being unchallenged by the fact that they were highly incentivized to say that to help the prosecution. And as we know, as soon as they
were highly incentivized to not get charged, right?
Yeah, absolutely. So, look, we all know how this works. When you have an situation like this, these witnesses are going to do what they need to do. They're going to say, oh, I think they want me to be a little bit more helpful. I think they want me to establish this fact a little better. So
I'm back to, there's no evidence contradicting what they said, and your client's testimony matches what they said.
I don't agree it matches, because...
Well, you didn't tell me you agreed it didn't match.
Well, I'm telling you right now, it's on page 220.
I don't have the transcript of the trial. It's in my brain permanently, but
I have it if you like it. My brief was 35 pages long. The court roll's only 20 pages. I mean, can I tell you something? My brief was actually closer to 45 pages at first.
It wasn't a brief.
Yeah, it's a oxymoron, isn't it? I'm not looking for praise for my brief. What I'm telling you is, now that we've drilled down on this issue of how it could have been contested, right here, Mrs. Crumbley's testimony on page 223, she disputes in principle and in character the testimony that she ended the meeting abruptly. Well, that's important. The jury says, oh, she didn't care. She just wanted to get out of there. She was in a hurry. That's damaging testimony. And if they didn't have any of that testimony from that meeting, then we're left with, he saw something 8 months earlier, and Mrs. Crumbley explained that and said, look, we tell jokes and stuff about this in ghosts. So the jury could have said, yeah, we believe that part, but now that we understand that
the defense attorney is pretty good. He's making good arguments in front of a hostile judge who's clearly going to rule against him.
Subjective descriptions about what occurred. It's that simple. I mean, this is materiality. If ever there was materiality, this is it. The Cheneau case isn't even come close to the facts in this case, because it was minor inconsistencies, it was cumulative, and there was no agreement by which to challenge the witness as being biased or having a motive.
There's other cases that say similar, right? There's other cases
that say similar.
Cheneau about materiality.
Oh, sure. There's more cases than we probably even need on the law books about materiality, Your Honor. Yeah. Right? If you want, we'll file all of them.
I wrote them all.
Well, then you've done more reading than me, because I can't say that I've read them all. You asked me when we started about the remedy.
Yeah, you know what? I don't believe the judge. I don't believe the judge. She's like, I've read them all. You've read all the cases on materiality? I don't know, man. I don't know. Are you sure? I don't know. I think the judge might have just told a little white lie on that one. I don't think that's true.
Is there a remedy if it's not a Brady violation?
Well, just before we get to that, if I could, please. I would ask the court to consider People versus Mumford. This is on page 9 of my motion, Court of Appeals case from 1990. It is axiomatic that the credibility of a witness is an issue of the utmost importance. It is also axiomatic that evidence of a witness's bias or interest in a case is highly relevant to his credibility.
I agree with that.
And that's the controlling standard. So it is impossible to say that these two witnesses' subjective descriptions were cumulative. It's not cumulative. It didn't come from anywhere else.
Yeah, it's not cumulative.
So
I agree.
I would ask the court to view that testimony and what happened through the lens of what the Court of Appeals said in the Mumford case, number one. But back to your question now about the remedy. The remedy I'm asking for, Your Honor, is an acquittal. And I have a case cited in my brief. That's the Causey case. It is an unpublished decision from the Michigan Court of Appeals.
Do you really think I'm going to do that?
Wow. Wow. I don't know, man. Wow. I don't know. That I don't know if I mean, the judge just said, "Do you think I'm going to do that?" It's like, "Do you think I'm going to do that?" It's like, I have a case. Do you think? Wow. I don't know, man.
No.
Okay.
But I want you to, because I think you should, and I think the most important reason why I think that you should is because the violation of the discovery rule in this case was intentional. This wasn't an oversight. And Chanel, it was an oversight, Your Honor, right? You agree?
There's other cases. There's a case that talks about a constitutional violation should be viewed by the quality of the evidence, not by something about the character of the prosecutor.
Well, you did say you've read more cases than me, so maybe that's why I didn't read. But can I just make a point about this my request for the dismissal? The remedies generally under Brady generally is a new trial. But in Michigan, we have the specific rule, MCR 6.201, which also provides that the court can take any action just to correct.
Oh, I found it.
Yeah.
If the suppression of evidence results in constitutional error, it's because of the character of the evidence, not the character of the prosecutor.
Oh, I'm not. I haven't said anything. You've told me I can't talk about the character of the prosecutor. I haven't talked anything about the character of the prosecutor.
You said they intentionally violated the discovery rule. That's what I'm.
But this is why I was making the distinction between MCR 6.201 and the federal cases about Brady,
Okay.
Because in Michigan, Your Honor, Brady and Giglio set the floor as to what the constitutional floor of rights is. Okay. Brady was decided in 1963, and it has been the law in the land since that date that the prosecution has to turn over favorable evidence. Michigan can decide that they want to offer greater protections than what Brady offers.
Yep.
So that's
why they get rid of Lester.
Huh? That's right. That's exactly right. That's why they get rid of Lester. Your Honor, it's almost so much fun that we're debating these cases. I
don't think so.
You don't? Okay. That's why they overruled Lester. The point is the Michigan courts can always decide to offer greater protections than those offered under the federal case law for Brady and Giglio, which I believe that was what you were reading from. Isn't it?
I think it is from Giglio.
See?
Do you want me
So
to
that
find it?
proves my point, Judge. You're reading from the
No, it's from Chanel.
Oh, shoot. Well. Either way, we're back to, I'm not challenging the character of the prosecutor as much as I'm trying to explain that this was intentional and it wasn't an oversight. And Chanel, the detective, was on the stand and he said, "Oh, wait, the defense doesn't have these videos? I thought they had the videos." So that was an unintentional or inadvertent suppression.
Okay, but what case says that?
What case is what?
I've had plenty of cases, actually in the past year, 2 different cases, where the prosecutor inadvertently did not provide some evidence. One was ballistics. Guess what? Brady violation. It's
Yeah.
over. There isn't a case that says intentional or unintentional, right? If
No,
there is,
but-
I'd like to know what it is.
Okay, but in Michigan, in the Causey case that you don't like,
I don't like it. Why?
well, you said you don't think I'm going to do that, do you? In Causey, they said that you could do it. In Causey, they said that dismissal is an available remedy.
No, you said acquittal. I mean, I guess it's the same.
I think it's the same. So in Causey, the court said that if you're going to consider a dismissal, we have to consider certain factors, and these are listed on page 5 of my brief. That is not brief, as you've indicated.
This lawyer is really, really good with a hostile judge. This lawyer is very, very good with a hostile judge. And it's like, he's like, in that case you don't like, well, why do you say I didn't like it? Because you said you weren't going to do it. And like the judge is basically pwned. The judge is basically like pwned. This lawyer is very, very good. I like this lawyer a lot. This judge is incredibly hostile to him. And he's like, let me just walk you through the law. He's on point, like, and he's making legally rooted arguments. He keeps citing case law. And that's why I like it, right? He's not making, like we had with Discount Wilford Brumley. Discount Wilford Brumley was making all emotional appeals. He's making policy appeals, right? He wasn't really citing law. This guy's citing law. He's like, how about this case? How about this case? How about this case? How about this case? And it's like, and he's citing legal principles, and he's using them to make his case to a judge who's incredibly hostile. And it's just like, and then he's like, oh, you don't like that case. Why you say I don't like that case? Why you say I don't like? Well, because you said you weren't going to do it. And that's why I said you didn't like the case. Oh, yeah. Yeah, okay. I like this lawyer very much.
And starting with People versus Al Hiswani, I won't go through these, but there's a number of factors that the court has to consider whether it wants to grant as to the appropriate remedy. If Your Honor doesn't accept the notion that a dismissal...
It's unpublished, right?
Yeah, it's unpublished.
And non-binding.
Yeah, you're right about that. We're all going to agree on that too, Your Honor. It's one thing before we leave here, that will be something we agree on. But these cases, and Leo is also cited in my brief, People versus Leo on page 6, same thing. These cases make clear, People versus Clark also, these cases make clear that the court should balance a number of factors when determining what the appropriate remedy is for a discovery.
It's interesting it's an unpublished decision, because usually what that means when it's unpublished is it means that there's another case somewhere that already says it, right? So like the court doesn't need to say it again. So it's weird that it's unpublished, because normally the way that I interpret that as a lawyer is it's like, oh, this is so rote. Like, you know, this is so rote. It's just like cite one of 300 other cases, right? But he's citing this, which suggests there is no other case he can cite, which makes it interesting that it's unpublished, because why did they make it non-precedential if it's new law? That's weird, right? Why did the Court of Appeals make it non-precedential if it's new law? That's okay. That's muy suspicious. Okay.
Violation, and Causey makes clear that the court can do so independent of whether it finds a Brady violation. Causey says, you know what, we don't have to concern ourselves with finding a technical...
Why is it going before this judge
violation.
anyway? Why is it go to the Court of Appeals? Well, it will eventually, but he's making a motion for a new trial before the trial court, which he's perfectly entitled to do. So the trial court can always reverse their own error. So, and also like and also it might be procedurally required by this to preserve the issue. So like, you know, he's going to make the issue here, and then he can make it, but before the Court of Appeals too. And then this judge might wind up getting smacked around by the Court of Appeals, although probably not, to be honest. I think this, I don't know, man. I think the courts are kind of inclined to look the other way on this one. I think they want their conviction, and I don't think they're going to do what they're supposed to do. So, yeah.
Brady, because in Michigan law, we can rely on MCR 6.201 to offer an additional remedy above the floor that's offered by Brady and Giglio.
Oh, I have no doubt it's going to the Supreme Court. I have no doubt in my mind.
I'm gonna read it.
Of the state.
Okay.
It's going to the Supreme Court of the
Would you like
state.
to hear anything else from me about the materiality and the proffer
Not at
agreement?
the moment. If I think of it, I'll let you know.
Okay.
All right?
Thank you, Your Honor.
This guy deserves a
You
round of
never
applause.
did grant
This guy deserves a round of applause. Incredibly well researched, incredibly well practiced. He's got his case law, he's got his argument, he's got his history. He made the argument about why these are material witnesses and why they're necessary witnesses, and why everything. I like this lawyer very much. Like he came prepared. He came prepared to make the argument, and he made a very good argument. So, like, win or lose, baby, you did great. Win or lose, baby, you did great. I'm very happy with you. You did an awesome job. I started watching because of Lawyers and Dragon. I was awesome on Trees of Attorney. Thank you. I enjoyed it. Yeah. I wanted to do it on a regular basis, but they couldn't fit me into the group for some reason. I was very disappointed because I like Dungeons and Dragons. And Ian said he thought that I might not have been put into the group on a regular basis because I'm a chaos agent. And I'm like, well, I don't necessarily have to be a chaos agent. That was just the character I was playing. Because I was playing this particular character. I could play a different kind of character if that's the problem. But it's like, apparently I've been branded a chaos agent. I've much like Gandalf. I've been labeled a disturber of the peace. Lol.
Motion to exceed that 20-page limit, although you told me my brief was...
I stopped reading it.
Oh my, well then, I'm in trouble if you start reading. But if we could just for housekeeping purposes at some point make clear that the motion has been accepted.
Mr. Peace.
Judge, there were so many fundamental misstatements of law and fact there.
Okay.
I'm going to need some time to reply. I will answer any questions you have.
Do you concede that there was a discovery then?
No, absolutely not. And I want to start off with a few things. And I'd call it gaslighting just now, but this isn't a game, Judge. It's not a game, okay? Number one, the prosecuting attorney made it clear as early as February of 2022 that the evidence that she had reviewed did not support charges of either Nick, Ejack, or Sean Hopkins. As early as February 22. Number two, we can't go back in time to manufacture a new defense when one is not supported by either facts or evidence. And I'll get to that later, Judge. Number three, those witnesses were subpoenaed to court. They didn't show up because of a proffer agreement. They were subpoenaed. In the plain language of the proffer agreement supports that.
But you didn't say that they had to testify, but they could have still taken the fifth, right? Yeah.
Any witness can attempt to take the fifth for any reason, Judge. Any witness can. There's nothing regarding the proffer agreements that indicates that the only reason they showed up to court was because of that.
Okay, but why didn't the prosecution provide that information? Maybe we wouldn't be here. I'm positive that decision wasn't an offhand decision by an APA or a Bates stamping.
I want to read the rest of the court rule that counsel didn't read through. And that's 6.201B5, the entire sentence, Judge.
Yeah.
Any plea agreement, grant of immunity, or other agreement for testimony. Testimony. Comma. There was no grant of immunity, Judge.
It's not use immunity?
It is not, Judge. The only way to grant immunity is to petition a court for immunity. It's to contain a verified statement to what these witnesses could be immune from. And the statutes on immunity, that's 767.A7 and 780.701, specify that. They also specify that immunity is regarding testimony. There was no agreement for testimony. I want to give the court a little bit of background.
There was an agreement not to use it in a case in chief if they were charged, right?
Anything they said in that meeting, yes. Yes, Judge. Mm-hmm. No agreement for testimony, no discussion of testimony. I want to go through the background of that, Judge. First, I want to talk about...
I'm going to let you say everything you want to say.
Thank you, Judge. Mm-hmm. Jennifer Crumbley was convicted based upon her level of gross negligence because she was the cause of these 4 deaths and because what her son did was reasonably foreseeable to her. Nobody else, her, Judge. That's why she was convicted. Now, the defendant claims...
Well, that's what the Court of Appeals talked about.
Yes, Judge. But she wasn't charged or convicted based upon anything that Hopkins or Ejack did. Okay, I want to go through the uncontested evidence, and that underscores that point. On November the 30th of 2021, and I'll be brief.
Well, I hate to interrupt you, but I'm not. Okay, so you've skipped to the Brady violation.
No, I haven't. I'm still in discovery.
Okay, well, I have a quote for you.
Should I continue, or would you like to ask a question?
I have a question for you.
Okay.
Because you said you didn't violate the discovery rules.
Correct.
Right? And this quote stood out to me. Unless indeed the adversary system of prosecution is to descend to a gladiatorial level, unmitigated by any prosecutorial obligation for the sake of the truth, the government simply cannot avoid responsibility for knowing when the suppression of evidence has come to portend such an effect on trial's outcome as to destroy confidence in its result. This means naturally that a prosecutor anxious about tacking too close to the wind will disclose a favorable piece of evidence. Didn't the prosecutor tack too close to the wind?
No, and I'll tell you why, Judge.
All right, good.
This prosecution was not premised upon either Crumbley or school liability. That is fundamentally false, Judge. And defense counsel's
a discovery violation.
Yes, Judge. It's part and parcel of that. Okay.
You're telling me why E.J. Hopkins, Mr. and Mrs. Crumbley could have all been charged and all had their own level of culpability. That's what that goes to materiality. I'm concerned about. Is the prosecutor allowed to take off the white hat for even 1 minute?
The prosecutor should follow the law, Judge, and that's what we did.
Yeah.
That's what we did. The plain language law. That's Sanford v. State from 2020. That's a Michigan Supreme Court case.
Yeah.
For testimony, that's a trailing modifier that applies equally to all three phrases, Judge. There was no immunity. That's the statute. No immunity, Judge. And nothing was offered for testimony. Now, again, I want to go through some uncontested facts. I want to talk about the background of how those proffers came to be. November the 30th of 21, the defendant's son committed the deadliest mass shooting in school shooting in Michigan history, where he killed Hannah St. Juliana, Madison Baldwin, Tate Muir, and Justin Schilling. He used the gun given to him as an early Christmas present and the ammunition the defendant bought for it just a few days before. The defendant's son, only friend that this defendant had ever seen around, was taken from him a month before the shooting, and she knew that. The defendant knew her son's proficiency with that firearm. In fact, he showed her how to use it just a few days before the shooting. The day before the shooting, she was called by the school and told that her son was looking up ammunition in school. That's November 29th. November 30th, the day of the shooting, she was called to the school, which all agreed took a great degree of concern, and shown that math worksheet where her son wrote the words, "The world is dead, help, my life is useless." He drew an identical handgun to the gun given to him just a few days before, a picture of a body with a bullet hole and blood. When she was shown that picture, her words, that she talked about her son was distraught the night before, her words, she said she was very concerned. At the meeting, she was given a list of mental health resources, told to contact that day. She didn't. In that meeting, she only confirmed information that either Hopkins or EJAC gave her. She didn't add any information. She didn't hug or attempt to hug her son. She didn't take him home. All agreed that there was never, you need to take your son home right now. You're forced to take your son home. Everybody agreed to that, Judge. That was never in dispute.
Well, Mr. Brady said they went on to testify that they thought it was strange.
Their subjective thoughts and views of that meeting have zero bearing on this case, Judge. Zero bearing. She didn't go home after the meeting to look for the gun. She knew that he couldn't be home alone that day. In fact, she texted her friend just that. And when news of the shooting broke, she knew it was him. Judge, that little snapshot is what is uncontested from November the 30th, that meeting, uncontested from those 12 minutes. Not just proven at trial with the evidence, because that would include a whole lot more. That would include the fact that that firearm was left unsecured and he had unfettered access to it. That would include the fact that she was adamantly aware of her son's deteriorating mental crisis that had occurred some months before. Those facts were proven at trial. But we're talking about just the meeting and what's not in dispute. Because the fact of the matter is that the majority of this case came through text messages, Facebook returns, GPS pings, phone tower records, and surveillance video. That's the bulk of the case. That what happened in that meeting, not in dispute at all. This is not a case of mistaken identity where witnesses had an incentive to identify a shooter as opposed to somebody else, like in Chanel. This is not that case, Judge. The fact of the sheer volume of uncontested evidence underscores that fact. So I want to talk about the proffer agreements themselves.
Do you agree that at the time of the proffer, Mr. EJAC and Mr. Hopkins were subject to potential criminal prosecution and knew it? They were incentivized.
No, I don't agree with that, Judge. I don't agree with that. No.
You don't think they knew?
They could. I don't know what was in their minds, and it doesn't matter. That's the point. There was intense.
If you had gone in there that day, wouldn't you have thought, geez, I could be subject to criminal prosecution.
I think even Mr. Hopkins testified he wished everything went different. He was the only one to testify that he wished that day had gone differently, Judge, and would have done something differently. Now, the fact of the matter is, after the shooting, in the wake of the shooting, there was intense media speculation, locally, nationally, and internationally, whether anybody in that school would be charged. Some of those individuals were afraid, Judge, I'm sure of it. That's why they retained attorneys. And our job before the preliminary examination is try to meet with everybody we can in those 30 days from the time of the shooting to the time where we had to charge our case and start to organize our proofs. That included individuals at the school. Two of those individuals who retained attorneys, their attorneys reached out to us. And although they were adamant whether their clients wished to cooperate and sit down and speak with us, for the attorney's own sake, they requested the first meeting to be in a proper setting, and we agreed. There was no promise. There was no threat. There was no discussion about testimony. We talked about what they did, what happened November the 30th, and that was entirely consistent with what they told the police on November 30th, 2021.
Wait, let me ask you that, because I think I sent an email to both sides. I was a little confused. So the video of EJAC during the proffer statement was not provided, but there was an initial police investigation.
Correct.
And the police talked to EJAC, Mr. EJAC and Mr. Hopkins initially, and a police report was generated, correct?
Yes, they were interviewed November the 30th, 2021.
Right.
That was recorded by the police.
Okay.
Narrative reports from the sheriff's office were generated regarding those.
Okay, and then when the proffer happened, like, who interviewed them? Did that end up being a police report?
No, it was our office, Judge.
And you just talked to them?
Correct.
Were the police there?
No. I want to talk about that Nick Ejak statement. I will in just a second.
Okay, all right.
Okay. So, there was never any agreement or promise for testimony. It plainly does not fit the court rule. And again, that's Sanford v. State. And we'll skip to this part in a second. But even if you were to find that violation, you would still need to find prejudice, which some of the questions you were asking the defense counsel.
Well, don't you think that credibility is always at issue when the defendant is not allowed to cross-examine about the circumstances surrounding the proffer? Doesn't that limit the information the jury may have about the credibility of the witness?
Their credibility didn't matter, Judge. It didn't matter what Sean Hopkins or Nick Ejak did or said. What matters is that Jennifer Crumbley knew all of this. She had 15 years experience with her son, and she got him a gun, and she knew it was unsecured, and she didn't tell anybody. That's not in dispute. And I have gone through that transcript, Judge, and there is no material dispute between Jennifer Crumbley, Sean Hopkins, or Nick Ejak from that meeting.
Here's a disconnect. You keep talking about materiality, which is really important, and I'm back on 6.201. Isn't the prosecutor under duty to disclose any information that would affect the credibility of the witness?
6.201, we're talking about the proffer statements themselves. They don't meet that definition, Judge. They don't meet that definition.
All right.
And I don't agree with the point that these proffer statements would affect the credibility of the witnesses. I don't agree with that, Judge. I want to talk about that statement from Nick Ejak. When this underscores the point that it was not for testimony. We didn't call him at preliminary examination. In fact, we hadn't intended...
EJAC, you didn't call EJAC.
Correct. We didn't intend to call him at all until defense counsel put Nick Ejak on her witness list in December of 2023 and indicated that she was going to call him. We decided we were better off to put him on in our case in chief as opposed to cross-examination. When we made that determination, we should have gone back through the case file and noted that interview, instead of work product, is now discovery. Because that now would have met 6.201, because that would be a statement by a witness, Judge, under the 1999 Court of Appeals case. I forget the name right now. We should have done that.
EJAC wasn't on your original witness list?
He was on the arrest just that witness list. We didn't intend to call him at trial.
Okay. All right.
We didn't need him. We didn't need him in an exam, Judge.
But you called him.
Because the bulk of what happened on November the 30th at the meeting was uncontested. But before this court even find a discovery violation, this court must find prejudice. And that's where we come back to this faulty misconception that this case was positioned as either Crumbley or the school for liability. The fact of the matter is, any line of questioning, any cross-examination of these witnesses to highlight their own perceived or real culpability would only serve to highlight the negligence on Jennifer Crumbley. Because all agreed what was conveyed to her on that meeting. All agreed. All agreed, which she did not convey back to those officials.
Yeah, but Mr. Desi, you put a black robe on, you can read people's minds. Mr. Desi is sitting there thinking, well, we wouldn't even have called her then, right? Because you're saying that her testimony confirmed what Mr. Hopkins and Mr. Ejak said, but Mr. Desi would say that Ms. Smith potentially would not have called Mrs. Crumbley if they did.
The bulk of the uncontested evidence doesn't come from her testimony. She spoke to police as well, Judge. These officers, or these individuals spoke to police as well. They testified, they were sued civilly. They testified at civil depositions. Defense counsel trial had that. In fact, she used those questions during cross-examination, and they testified later on in trial. They were consistent all along the way. The uncontested evidence doesn't come from her testimony alone, Judge.
I forgot about the civil depositions. When were they chronologically?
After exam, before trial. I couldn't tell you the date.
Okay.
But we know with certainty that counsel had those because she referred to a page of the deposition during cross-examination. Judge, there can be no I disagree fundamentally with counsel. This is not cumulative evidence. There can be no prejudice, especially the Nick Ejak statement. It only supports the prosecution theory. It only bolsters it, Judge. There's no inconsistencies there.
That doesn't mean that it's not cumulative. That also is the problem to some degree. Like, yeah, it bolsters the prosecution's case. That's kind of the problem. Right? It's like, wait a second. That's the thing, man. It bolstered your case. It made it better. It made it okay. Yeah. What is another way of phrasing that, right? It's like, oh, it bolstered the case. It made it better. It improved it. It changed it in a blank way. Material, maybe? Yeah. Yeah.
Brady, when we get to Brady's when we talk about favorability and materiality, because the court is correct. Before a Brady violation is found, you need to show that this evidence is either impeaching or exculpatory, and that a materiality is a reasonable probability that the evidence, had it been disclosed, would result in a different outcome. That is not here. That is not the case here, Judge. There can be no showing of materiality.
Outcome is the confidence in the outcome.
Can you say that again?
Clear appreciation of the delegation of Algeria, to all members of the Council, and to the Secretariat for their invaluable support throughout this month. We had hoped for a calm, quiet beginning of the year, but as often happens, we have had a rather eventful.
Well, I didn't realize how big the Crumbley case had become. I didn't realize how important the Crumbley case had become. Apparently, it's become a matter for the United Nations, and the country of Algeria has some thoughts on the subject. Wow. That I didn't realize it got that big. Cool. Well, that's the end of the hearing. Once again, I've been lied to and bamboozled. I've been lied to and bamboozled. Watch, Oxford school shooter mother, Jennifer demands new trial. And what I got instead is Algeria talking about stuff. Well, okay. Does it ever go back to Crumbley? No, it doesn't. What it does go to is a hallway full of flags. Let us admire the hallway full of flags. It is a nice hallway full of flags. I'm not 100% sure how the hallway full of flags relates to the Oxford High School shooter, but you know, nice. Apparently, the Security Council has gotten involved with the Oxford school shooting. Holy shit. The Security Council's involved. Holy shit. Wow. Okay. Let's see if we can find a different feed.
Remember this trial.
Oh my God. All right. Are you a hearing? You look like you might be a hearing. All right, let's give this a shot. This is not my fault. I want it to be noted for the record. This is not my fault. I'm not a boomer.
Works when you have an situation like this. These witnesses are.
The fact of the matter is, any line of questioning.
Oh, this is great.
To highlight the
This is good. I have no audio.
would only serve to highlight.
Let's listen really closely.
Because all agreed what was conveyed to her on that meeting. All agreed. All agreed what she did not convey back to those officials.
All right, how about WXYZ TV?
A new trial. As you're well aware, prosecution provide that information. Maybe we wouldn't be here. I'm positive that decision wasn't an offhand decision.
Case made clear.
Mr. Keys.
Judge, there was so many testimony. There was no agreement for testimony.
Cannot avoid responsibility for knowing when the suppression of evidence has come to portend such an effect on trial's outcome as to destroy confidence in its result.
The defendant fought for just a few days before. The defendant's son, only friend that this defendant had ever seen around, was taken from him a month before the shooting, and she knew that. The defendant knew her son's proficiency with that firearm. In fact, he showed her
Prosecutor, anxious of,
point. On November the 30th of 2021, and I'll be brief.
well, I hate to interrupt you, but I'm gonna. Okay, so you've skipped.
Where were we in this thing? Where do I scroll to?
I'm still in discovery.
Okay.
6.201, we're talking about the proffer statements themselves. They don't meet that definition, Judge. They don't meet that definition.
All right.
And I don't agree with the point that these proffer statements would affect the credibility of the witnesses. I don't agree with that, Judge. I want to talk about that statement from Nikki Jack. When this underscores the point that, so I want to talk about the proffer agreements themselves.
Do you agree that at the time of the proffer, Mr. Ejak and Mr. Hopkins were subject to potential criminal prosecution?
All right, I'm going to pick it up here. This is fine.
No, I don't agree with that, Judge.
I'm going to pick it up
I don't
here.
agree with
This
that.
is fine.
No.
You don't think they knew, gee,
They could, I don't know what was in their minds, and it doesn't matter. That's the point. There was intense.
if you had gone in there that day, wouldn't you have thought, geez, I could be subject to criminal prosecution?
I think even Mr. Hopkins testified he wished everything went different. He was the only one to testify that he wished that day had gone differently, Judge, and would have done something
Also,
different. Now,
I'd like to take note that it says I'm streaming in 720p from the original source, but in fact, I'm streaming from a potato. It says it's 720p, but it's a potato. Ugh.
fact of the matter is, after the shooting, in the wake of the shooting, there was intense media speculation, locally, nationally, and internationally, whether anybody
Potato Cam's going to have to do.
Some of those individuals were afraid, Judge. I'm sure of it. That's why they retained attorneys. And our job before the preliminary examination is try to meet with everybody we can in those 30 days from the time of the shooting to the time where we had to charge our case and start to organize our proofs. That included individuals at the school. Two of those individuals who retained attorneys, their attorneys reached out to us. And although they were adamant whether their clients wished to cooperate and sit down and speak with us, For the attorney's own sake, they requested the first meeting to be in a proper setting, and we agreed. There was no promise. There was no threat. There was no discussion about testimony. We talked about what they did, what happened November the 30th, and that was entirely consistent with what they told the police on November 30th, 2021.
Wait, let me ask you that, because I think I sent an email to both sides. I was a little confused. So the video of EJAC during the proffered statement was not provided, but there was an initial police investigation.
Correct.
And talked to EJAC. Correct.
One.
Again, this is not my fault. You can see the timer. The timer is running. The stream is running.
Talk to them.
This is not my fault.
No. No. I want to talk
Oh,
about
we're
that-
back to
that
potato.
statement. I will in just a second.
Okay. All right.
Okay. So there was never any agreement.
No,
or
we're not even at potato quality.
Plainly does not fit the court rule. And again, that's Sanford.
Now
v.
we're
State.
streaming with an onion.
We'll skip to this part in a second. But even if you were to find that violation, you would still need to find prejudice, which some of the questions you were asking.
Well, don't you think that credibility is always at issue, and the defendant is not allowed to cross-examine about the circumstances surrounding the proffer? Doesn't that limit the information the jury may have about the credibility of the witness?
Their credibility didn't matter, Judge. It didn't matter what Sean Hopkins or Nick Ejak did or said. What matters is that Jennifer Crumbley knew all of this. She had 15 years experience with her son, and she got him a gun, and she knew it was unsecured. And she
Can I
didn't-
just say that the stream randomly switching to the UN is one of the more unintentionally hilarious things that's happened on stream in a while? That is just like really funny. We're just streaming, and all of a sudden Algeria is speaking. And I'm like, what the hell happened? Did I suddenly somehow misclick? What happened? Did I suddenly somehow get redirected into a different stream? No, it's just the same stream. Now we're just talking about Algeria for some reason. What the hell? What the hell? That is just like, unexpected Algeria in my life. It's like, okay, yep, fine. Algeria somehow in my life today. That's fine.
Tell anybody. That's not in dispute. And I have gone through that transcript, Judge, and there is no material dispute between Jennifer Crumbley, Sean Hopkins, or Nick Ejak in that meeting.
Here's a disconnect. You keep talking about materiality, which is really important, and I'm back on 6.201. Isn't the prosecutor under duty to
I
disclose
feel the
any
rains
information
down in
that affects
Africa. But the
6.201, the proper statements themselves, they don't meet that definition, Judge. They don't meet that
she's
definition.
waiting there for you.
All right.
And I don't agree with the point that these proffer statements would affect the credibility of the witnesses. I don't agree with that, Judge. I want to talk about that statement from Nick Ejak. When this underscores the point that it was not for testimony. We didn't call him at preliminary examination. In fact, we hadn't intended.
EJAC, you didn't call EJAC.
Correct.
Okay.
We didn't intend to call him at all until defense counsel put Nick Ejak on her witness list in December of 2023 and indicated that she was going to call him. We decided we were better off to put him on in our case in chief as opposed to cross-examination. When we made that determination, we should have gone back through the case file and noted that interview, instead of work product, is now discovery. Because that now would have met 6.201, because that would be a statement by a witness, Judge, under the 1999 Court of Appeals case. I forget the name right now. We should have done that.
Wait, EJAC wasn't on your original witness list?
He was on the arrest just that witness list. We didn't intend to call him at trial.
Okay. Right.
We didn't need him. We didn't need him at an exam, Judge. Again, because the bulk of what happened on November the 30th at the meeting was uncontested. But before this court even find a discovery violation, this court must find prejudice. And that's where we come back to this faulty misconception that this case was positioned as either Crumbley or the school for liability. The fact of the matter is, any line of questioning, any cross-examination of these witnesses to highlight their own perceived or real culpability would only serve to highlight the negligence on Jennifer Crumbley. Because all agreed.
If that's true, then you should have done that yourself, right? I mean, like that's a really dumb argument. That's that's a disingenuous argument. I don't like that. You know, if they had shown how the school principal and the teacher were guilty, it would have only proved all the more how Crumbley was guilty. Bullshit. Bullshit.
What was conveyed to her in that meeting? All agreed. All agreed, which she did not convey back to those officials.
Yeah, but Mr. Desi, you know, you put a black robe on, you can read people's minds. Mr. Desi is sitting there thinking, well, we wouldn't even have called her then, right? Because you're saying that her testimony confirmed what Mr. Hopkins and Mr. Ejak said. But Mr. Desi would say that Ms. Smith potentially would not have called Mrs. Crumbley if they didn't.
The bulk of the uncontested evidence doesn't come from her testimony. She spoke to police as well, Judge. These officers, or these individuals spoke to police as well. They testified, they were sued civilly. They testified at civil depositions. Defense counsel trial had that. In fact, she used those questions during cross-examination, and they testified later on at trial. They were consistent all along the way. The uncontested evidence doesn't come from her testimony alone, Judge.
I forgot about the civil depositions. When were they chronologically?
After exam, before trial. I couldn't tell you the date.
Okay.
But we know with certainty that counsel had those because she referred to a page of the deposition during cross-examination. Judge, there can be no I disagree fundamentally with counsel. This is not cumulative evidence. There can be no prejudice, especially the Nick Ejak statement. It only supports the prosecution theory. It only bolsters it, Judge. There's no inconsistencies there. Now, when we get to Brady, is when we talk about favorability and materiality, because the court is correct. Before a Brady violation is found, you need to show that this evidence is either impeaching or exculpatory, and that a materiality is a reasonable probability that the evidence, had it been disclosed, would result in a different outcome. That is not here. That is not the case here, Judge. There can be no showing of materiality.
Not a different outcome is the confidence in the outcome.
Can you say that again?
I don't know. When we were talking about these cases, this case, like, it's not my job to say, oh, I think the jury verdict would have been different. Like, that's not my job, right? But my job is to say, do we now lack confidence about the verdict?
Right.
It's a different thing, right?
The standard is reasonable probability that had the evidence been disclosed to defense, the result of the proceeding would have been different. Kyle's talks about, in essence, is this a verdict worthy of confidence? I agree with that. It absolutely is, Judge. Again, this has never been the case. Our prosecution never hinged upon any perceived or real liability on behalf of Sean Hopkins and Nick Ejak. Should they be successfully sued or successfully prosecuted at some point in the future, that would have zero impact on Jennifer Crumbley's convictions, because she was convicted based upon what she didn't tell anybody, what she knew, what she didn't do. The level of uncontested evidence there, that's what speaks volumes, that's what shows and underscores the level of confidence in this verdict. Does the judge have any further questions on this topic?
Not at this exact moment. I'm going to let Mr. Desi respond if he would like. I'm going to let you respond. I'm going to let everybody say whatever they want. In the end, one side or the other won't be happy, but they won't say it and listen. So
that's fine, Judge. Thank you, Judge.
Thank you. Mr. Desi?
Yeah, just a brief detour from the substance of this. I would be remiss if I also didn't tell the court. I have a third law student who isn't here, and I forgot to mention her, and it's important to me that I want to tell you that I also have a third student by the name of Stefania Ilievska, who's also assisted and been working on the case. She's not here today, she couldn't be here, but I don't want that to be unsaid. So with that, Your Honor, I'd skip back to getting into what Mr. Keast said. He just said, well, we didn't even need Ejak, we were going to call him. Well, then why did you call him? I'll tell you why.
He told you why.
Well,
Ms. Smith was going to call him.
Well, we're adversaries, so I don't have to accept his assertion as to why he called him or didn't call him.
Well, it would make sense because it was a chronology, because Mr. Hopkins talked about what happened in the office, and then Mr. Ejak came down, so
You're not
chronologically,
you're not gonna like what I'm gonna say, but they called him because they wanted him to say that it seemed a little odd. Typically, parents follow the direction. They called him to get those back to this subjective descriptions that they could then use as the basis for gross negligence. Okay, so the prosecution's just being absolutely recalcitrant about even acknowledging what MCR 6.201 says, even though we talked about gaslighting and what the husband was trying to do with his wife. They're still saying it's not an immunity agreement. Well, then they don't understand what a use immunity is. If that's the case, respectfully, they're just telling us not to believe something we can see with our own eyes. The subjective testimony is the key, and I know you said you read everything. I don't want to get caught up in my papers, but Mr. Hopkins also provided a wealth of subjective testimony. He had concerns of suicide. That was on, of course, you already know that. I don't have to tell you.
Yes.
He didn't want him left alone. He wanted him to be seen as soon as possible. I wasn't expecting them not to follow through, page 138 of Mr. Hopkins. Why am I telling you this? Because this is subjective testimony that went to the core of gross negligence. But here's my other real dispute with the prosecution and what they're arguing. They're arguing that there's sufficient evidence notwithstanding. That is not the standard. Materiality is not a standard of sufficiency of the evidence. Sufficiency of the evidence just says, well, there's other stuff that would support the conviction. That's not what we're doing here.
Well, that's about the confidence. That goes to whether or not you have confidence in the result, but it also goes to whether or not there's a difference between credibility and impeaching of the testimony. So they also say that
Sure.
Other evidence provided in the trial supports what Mr. Ejek and Mr. Hopkins said.
Well, yes and no, because the prosecutor also said, oh, there was this, there was this, there was this, there was all of these other things. So what he's suggesting to you is you should find that there was sufficient evidence.
Why do I have random pop-ups popping up on my browser?
There's case law.
What the fuck?
35 pages. I told you I already edited out about 10 pages. But I had a lot of case law in there about this exact point, and I took it out because I didn't think we were going to fight about it, or just I shouldn't say fight.
I don't even think I have that extension. Oh, there it is. Fuck you.
There's lots of case law that says materiality
Goodbye, extension. God damn it.
Dependent on a sufficiency of the evidence. And it's back to what Your Honor said with Chenault. We have to ask, can we have confidence in this verdict, not given the fact that they withheld and suppressed this information? I understand why the prosecutor wants to tell you they didn't have to give the agreements, because it's so obvious the materiality is met in this case. So they're going to go back to square one and say, well, we didn't have to give the agreements.
I'm just waiting for the prawn pop up. That's all I'm waiting for. That's all I'm waiting for. When will it happen? When will it happen? Yep.
We don't think we needed to provide them under 6.21. We're not going to go back through it because we can read it for our own eyes. So I would suggest that the materiality in this instance is easily demonstrated. I don't even think it's a close call because there was no other testimony about that meeting. And don't forget, the prosecutor stood up in the closing and they mentioned all the things about what they believe Mrs. Crumbley could have and should have done and how she was despondent or disinterested during the meeting. So obviously it was important to them because they elevated it to the point of putting it in their closing argument. I'm sorry I've wandered around. My colleague, Mr. Brochet, told me to stop. I teach and I move all around the classroom all the time, so I can't help myself. He told me to stop, though, Judge, just so you know. All right. If you have any other questions for me, I'm happy to answer them, but I believe that we've...
I don't think I do. I mean, anything else, prosecutor?
Just very briefly. I'll keep it
ahead.
very
I'm gonna let you...
You've been very patient. I appreciate that, Judge. Now, I just want to, again, hit the point that Sean Hopkins or Nick Ejak's perception of what is odd is simply meaningless, Judge. Simply meaningless. Jennifer Crumbley knew the background. Jennifer Crumbley knew what that drawing meant. Jennifer Crumbley had the opportunity to take her son home. She chose not to. Jennifer Crumbley should have gone home and looked for the gun. She should have looked in the backpack. She should have put the pieces together. The objective, uncontested evidence is why this verdict is worthy of confidence, Judge. And regarding the proffer statement, again, I just want the court to follow the plain language of the law. That is the law in the state of Michigan. Sanford v. State. For testimony is the operative phrase. There wasn't like there was some roundtable discussion to hide evidence, Judge. It didn't fit the definition, and we never revisited it because it just doesn't fit the definition of disclosure. Okay? I don't want there to be any sort of allegation.
You'll do the White House press conference after this.
I know the court.
We're almost done with this. We'll do the White House press conference in a second.
Thank you, Judge.
All right, anything else?
I think it's time for another stream, guys. I think it's time for another stream.
I wanted to talk about, so
Because it doesn't.
And then maybe we'll go back to the UN. Who knows?
It might be of interest in the future, but the prosecutor, for one thing, the prosecutor it wasn't in your brief initially, and the prosecutor wasn't permitted to respond. And I don't know how hiring someone to field questions from the press or PR or any kind of press videotape could impact the decision with regard to the motion that you filed. I'm not saying it might be relevant in the future. I don't know that, but
I have to be honest. I really don't know much about Algerian law,
job, Mr. Desi, as you know.
so I'm not sure how helpful I'll be on that channel.
Persuade me that her position is consistent with the law. And I guess what I'm saying is that information.
Was Algeria at some point a British colony? Maybe I can get by.
As I believe it's irrelevant to the current motion. All right?
Just
So
for
it
the
doesn't
record,
help me.
I just want to point, it's not a PR firm, okay? Again,
I don't
fundamental
know.
misconception.
I don't
not a
know.
PR firm.
I mean, they were social media influencers, Your Honor.
Oh,
French?
Social media influencers. And their own websites say, they tell us in their own
all right.
words.
So,
The county hired this.
you guys just can't help it, right?
No, I can't. I
Oh
can't.
my gosh. You could talk to the press about it outside. I'm sure I know they're very interested in it. I don't think it helps me resolve the motion, so it's not up to me, all
Thank you,
right?
Judge.
So with regard to the defendant's motion for bond pending appeal, a ruling on this motion is obviously impactful. Therefore, I'll rule on the motion for bond pending appeal contemporaneous with a written opinion on the motion for acquittal and or new trial,
All right, fair
Thank you,
enough.
Judge.
right?
Would you be bringing us back then for any?
I haven't decided yet.
Okay, fair
That's all I
enough.
could do to get to this point, Mr. Desi.
I cut my brief
Yeah.
down, Your Honor,
Yeah.
as much as I could.
All right. So I would like to ask that everyone remain seated while the defendant is removed from the courtroom. All right?
That judge is an interesting judge. That judge is interesting.
Yeah, she'll be sent back right away.
Okay.
She's kind of hostile to everybody, which is definitely one way to go. I don't know what I think about her yet. The judge is kind of hostile to everybody.
Understood.
She's cranky.
I suspect that they
She's a
will
cranky old man judge.
quickly. I suspect.
Okay, well, I guess that's the end of that. Let's see what's going on with the White House. Lord.
You said you wanted to raise a legal
January
issue.
28th.
What's the legal issue?
Shut up. All right, let's see. Okay, should we start a new stream? I think we should start a new stream. We're 5 minutes behind. Okay, that's fine. Yeah, we can do that. All right, new stream time. New stream time is glorious time for you and me, baby. New stream time is glorious time for you and me. Shut up. I'm not busy. I'm trying to create a new stream. Stop talking, White House. All right, let's see. Create new. All right. White House press conference. Jan 31. 2025. Is it still 2025? For the moment. Okay, that's great. All right. Subscriber. Any duration. Slow mode 15 seconds. Public. Yeah, great. Yeah. Maybe Algeria is relevant to what's going on in the world. Can't say that Algerian news crosses my desk very often, but you know, what can you do? All right, guys, I'm going to start a new stream. I'll see you over there in just a second. All right, you should be redirected automatically. If not, you know the deal. Find this thing on your page and all that, right, and all that good shit. All right, I'll see you guys in a second. Love you lots. Bye.